All right, we will call to order the full committee of Judiciary A. Before I get started, as I've mentioned to the committee members and to the public, we're operating under the subcommittee system, and I think it's been going real well. And I want to thank my subcommittee chairman for the hard work that they've put in, because I think it is certainly helping the committee. We may even have more bills than we did last year, so I appreciate it. And today on the agenda, we're just going to go down. We're going to try to get to as many as we can in this hour. Most of these are double referred or hopefully less controversial than normal. So that's what the agenda. So we're going to start with, and I'm going to ask, unless you choose not to, but the subcommittee chairs to present the bills that are that came out of your subcommittee on that. So, all right, we will start with under Civil Law and Procedure, Senate Bill 2322. Senator McCon.
Mr. Chairman, I appreciate you calling that one up. I am going to go ahead and use that privilege and ask Senator McDaniel, because this was his bill. Okay. I'll be happy to take the rest of them up, but that's his bill.
Thank you, Mr. Chairman. Long and short of this bill, you'll see the operative language there beginning on lines 52. And I received a call as well as Senator Fillingain, and I think you as well, Mr. Chairman, from Jenny Nico, who is the administrative law judge on the coast. And what she's requesting is that when there is a hearing before her, or for that matter, any workers' comp judge or administrative law judge, that the court reporter provide a copy of the transcript to the court upon request. And that's all the bill does. It mandates the court reporter will provide that transcript, and that way she can depend on that to write her opinion as opposed to those hand notes. That's all the bill does. Now, I do have, at the proper time, a quick amendment.
Okay, now's the time.
Okay. Just to clarify, this is for administrative law judges. If you'll look down there, I guess roughly around line 54, we might want to just spell that out. Administrative law judges. And that was by her request as well. She was concerned that the language was a bit too vague and wanted to see that addressed.
That's your amendment?
That's it.
Okay, we're on the amendment. Do we have any discussion on the amendment? All in favor of the amendment, say aye. All opposed, amendment carries. Okay, we're on the bill itself. Any questions on the?
Mr. Chairman, just a moment, if you don't mind.
Yeah.
Looks like it's not, we don't have a whole committee, so it added within 60 days.
Right, and that went at the
So
bottom
I'll
of.
make that amendment.
Okay, so that's going to be where, Mr. Chairman, provide a transcript hearing within 60. I believe that if you go to number 2 and just put within 60 days, you can just do another amendment on that.
Can you explain?
Yeah, there was an amendment made in the subcommittee. Basically, it was a timetable. In other words, within 60 days from request. And we made the amendment there. It just hasn't made it.
Okay, I think that's what Ethan's saying. It didn't make it onto the copy, but it's in the committee substitute, the subcommittee substitute, I guess. And so your amendment is to amend, to add that language on your amendment to the committee substitute of the subcommittee.
That's correct.
Okay. Any questions on the bill? All in favor, say aye. All opposed? All right, that passes, and that is double referred, so that'll go to Judiciary B, which is meeting tomorrow. All right, next one, Senate Bill 2460, Mississippi Domestic Law Task Force.
Yes, Mr. Chairman. This bill right here, last year we established the Domestic Relations Task Force. That worked so well, and we have so many great ideas that have come from it that they've requested for this to continue forward. This bill merely extends that out another year to allow them to provide us some additional information for next year. The motion would be title sufficient, do pass.
Okay, and I would add that to Senator McConn's point, yes, the Domestic Law Task Force was well received, and Justice Griffiths, Judge Odom and all requested that they continue, that this be reconstituted, and that's what this bill does. So any questions on the bill? All in favor, say aye.
Aye.
All opposed? Bill carries. Okay, next I'm going to call up Senate Bill 2509. That will be the outdoor advertising signs, and we have Mr. Baker, would you like to come present? And I will tell you that this bill, first of all, is double referred to Highways and Transportation. We did pass this, actually this bill came over from the House last year. And we did pass it, if I'm not mistaken. Oh, no, I'm sorry. I don't think it passed out of committee. My understanding is that some work has been done on it. And Mr. Baker, I forewarn you, your reputation precedes you. So, and you know, you had that House member out in front of you, so we'll take it easy on you.
Got it. Excuse me, I'm sorry. This bill started in a form a few sessions back to address a problem that was that occurred in 2008 with regard to sign height issues, particularly with regard to an area down on the coast. Senator Hughes, now Mayor Hughes, had and the outdoor advertisers had agreed on some language that was put into the law. Unfortunately, however, there was a typo in the legislation that was passed, and the old language was carried forward with the new language. And so what in essence, what happened was there was a sign height limitation, and all of the signs were then, all signs in the state of Mississippi over 40 feet were declared non-conforming uses by that language, which was not the intent. That being the case, there was years of litigation that followed, which has since been resolved. Last session, we brought a bill to correct that issue. However, there were some issues raised by MDOT at the last minute. Over the summer, I have worked with MDOT on the language, and this bill is the language that I received from MDOT, to which they had no opposition. And so in essence, what this will do is with regard to height limitations, we'll put this regulation, this will be regulated by counties and cities as it is now, because I want you to know that if a city or a county has a more restrictive height limitation, that one carries. And most do, except for where they don't want to. For example, on I-10, where those cities want a higher sign. But in those cases, those are conditional uses handled by ordinance. Applications are filed, maintenance is required. And so the cities and counties are regulating this as it is presently. And so MDOT, and I think correctly so, decided that they themselves don't need to be in the height limitation business. Now, all of the other issues that MDOT has with regard to illumination and proximity and location in relation to clover leaves and all that remains. None of that changes, as you can tell by the bill that we've presented. And it is double referred, so I'm going to have to go to transportation and work with Chairman Branning there, hopefully. And
on that, I will just note that I think Chairwoman Branning and I think if it passes here, the issues, that's why it's going to Highways and Transportation, and she'll have questions and you can work with her on that.
Absolutely.
Okay.
Absolutely. And look forward to that. Thank you.
Mark, I would ask this, can you put, because I've heard a lot of different ones, you know, sign heights, all that. Can you put it in a nutshell what this whole dispute has been about?
So,
and by the way, I will note that Senator Harkins authored the bill.
that's correct. So in 2008,
Nutshell.
okay. Billy Hughes wanted to get into the sign regulation, height regulation business insofar as it pertains to sign stock on the coast. Okay, he just did. The problem is that we had just kind of come through Katrina as well. And so there were concerns there. And so the intent was to grandfather in all signs that predated that initial legislation and then go forward. Well, the problem was that by the nature of that language, everything was grandfathered. And where this came up, how this started was there was a high sign that one of the outdoor advertisers actually wanted to lower. And the position of MDOT was, is if you lower that sign, you have to take it down because of this statute and of the statute as it was drafted. And so that's how this all got started. Everybody, and I've passed this out previously, but the federal judge in summarizing this said everybody agrees what the intent was. Unfortunately, the language of the statute doesn't say that. And so they had to apply the statute as written.
Okay. Any questions? What's your name? Senator Barnett.
Oh, no.
Sorry.
Dang. I don't know if I should thank you, Mr. Chairman, or not.
Sorry.
Anyway, Mr. Baker, last year, when you brought this bill before us, the question that didn't get answered then, and I haven't heard you talk about it yet, is that how are you all going to fix the problems with conforming and non-conforming signs? And I haven't heard you address that at all.
Okay. Well, the issue that the original legislation was for was with regard to a height issue. This legislation is different from last year because it goes straight in and goes just to that paragraph and removes that height issue out. That will now be an issue that will be controlled and regulated as it is already by counties and municipalities. And whether or not something is conforming or non-conforming under a county zoning ordinance or a sign ordinance, or under a municipal sign ordinance or zoning ordinance will not change. In many places throughout Mississippi, I can give you several cities just in the Jackson metro area. You have most of your billboard signs, outdoor advertising signs are grandfathered in. They're all considered non-conforming uses and therefore are subject to the city zoning ordinance as to non-conforming uses. Some cities like Jackson have what they call a cap and replace, which says that the number of signs that you can have, outdoor advertising signs, is this. And to put another sign up, you've got to reduce so many faces to do that. And so that's non-conforming is being handled by and is handled by local zoning ordinances from the counties and the cities.
But that's, you still not, we talking about, when we talking about the signs, we was talking about, on ramps, getting on and getting off. And none of these things are, these are all access of MDOT, not cities and counties.
Right. And
you haven't addressed that.
Well, none of
either
that.
yet.
Yes, sir. I'm sorry, Senator. None of that's been changed. That's still in the law.
If I remember last year, those were the problems that we had, and we still haven't addressed those yet. We're not talking about city and counties. This was all dealing with MDOT and those things. We're not talking about cities and counties.
Yes, sir. The bill from last year, this is not the same language. This is not the same as it was last year. Those concerns that you had with regard to the other aspects of the bill, they remain in this bill. They're here. They haven't been changed at all.
So we really haven't done anything to fix the problem that we had last year, basically.
We are addressing the height issue, but the issues that you're talking about remain. The concerns that you had last year are not affected at all by this bill.
But if this bill goes into effect, then it would affect all of it, not just the height, right?
No, sir. The current law would prevail on that. We're not affecting current law at all in that regard.
Motion at the proper time, Mr. Chairman.
Any other questions? Now's the proper. Your motion, now's the proper time for your motion.
Thank you, Mr. Chair. A motion that we table this to a later date, if that's the proper.
Well, you can certainly, we'll vote on your motion, but it is double referred.
I understand.
So, and as I sit here, a lot of these questions seem to deal with highways with deference to my vice chairman. So I think, to be honest, I've never been on highways, and so I'm not really sure. What this is looking at, this committee, is from the legal side of this. And what I've heard is that they've worked on to try to address it. I think the issues have been from the highway side, which again is why it's double referred. So,
Question for
yes.
Senator Barnett. Since it is, if your motion prevails, that would essentially, from what I'm hearing, be a killing motion.
Yeah, what?
It would be a killing motion. In other
Well, we
words,
still have time. I mean, the deadline is up to next week.
that's kind of my point, though. So if we pass it here, it still goes to highways. You'll have your chance there, perhaps to rectify the concerns you've got. I'm afraid that if you take the action you do, the bill will just die. And I think the bill is probably a good bill. Would it be okay? I mean, I'm asking. You may want it dead, but you still have a chance to talk to Senator Branning and rectify those concerns without killing the bill today, I guess is my concern.
Well, I'm gonna leave my motion where it is and I'll let the members of this committee decide if y'all want to move it forward or hold it on the motion, I mean, at the table.
Would you like, okay, since it's your motion, we'll have, you can speak in favor of your motion if anybody wants to speak against the motion. Yes, on the motion? Yes.
The bar, you're wanting to table it for further consideration before this committee? Okay, but would you not, would the appropriate motion be then tabled subject to call? Because as Senator McDaniel has indicated, a tabling motion means it can't come back up.
I'll take Senator Blackman's motion.
So you're amending your motion?
Yes, I'm amending my motion.
I love a committee full of lawyers. Okay, so the motion is table subject to call.
That's correct. Lay on the table, subject to call.
Okay, Senator Hobson.
Parliamentary or point of order, I guess, is it subject to call of the chair or subject to call period so that the committee has the ability to bring it back up?
I will say the committee, we plan to have, we certainly will have at least one more committee. And so if it's subject to call of the chair, I'm sorry, subject to call, it will end up on the agenda for it to be brought back up by the committee.
And the committee could make the motion to remove it from the table at that time.
Correct.
Thank you, Mr. Chair.
Anybody else want to speak on the motion? All right, the motion is subject to call. I'm sorry, motion to lay it on the table, subject to call. All in favor, say aye. All opposed? The noes have it. All right, back on the bill. Do I have any other questions on the bill? Have a motion. Motion's title sufficient, do pass. All in favor, say aye. All opposed? Motion carries. That will be reported to Highways and Transportation. Good luck, Senator Branning. All right. All right, moving to ad hoc subcommittee. We'll call it Senate Bill 2350 and turn it over to Senator Boyd.
Thank you, Mr. Chairman. This is a bill that was brought to Senator Kaufman, and I believe the same bill has passed before this chamber before. And I will tell y'all that I have had an outpouring of individuals who have been in this particular situation who have reached out since we passed it out of subcommittee. What this bill does is it allows for individuals who've adopted a foreign child to be able to get a certificate of foreign adoption. And why this is very important to them is, as you can imagine, I don't know how many of y'all have lost your children's birth certificate, but I'm rather the queen of it. And so I have a place that I can go, that I can get new birth certificates. When these parents adopt children in a foreign nation, sometimes procuring those birth certificates, again, is extremely difficult and financially not even feasible, at many points in times. Governments change, their leadership changes, and procuring these documents has been very, very difficult for them. So what this does is it gives us a process to do this within the state health department, within the Bureau of Vital Statistics. I've reached out to them to make sure that they had no additions that they would make to this. They have not reported that they have any to make. And we're very much following what is kind of the standard in most other states. I've looked at them to see if we're kind of following this. So I'll entertain any questions that y'all have on this.
Senator Hobson?
Thank you, Mr. Chair. Senator Boyd, if I may question you, what does this change from the foreign adoption law that we passed in Mississippi 7 or 8 years ago?
This really has to do with the birth certificate. So I'm not sure about the foreign adoption law, Senator Hobson, that y'all passed several years ago. This strictly has to do with, we are following still federal law here, following the state law on this. This has to do with issuing the birth certificate, the certificate of foreign adoption. And so this is an entirely new code section on this.
Yeah, I'm looking at the foreign adoption law that we passed, and it states very similarly to this, that, you know, if they follow these guidelines, they may be issued the birth certificate. Are we having a problem with that?
Yes, sir. We don't have from the families that I've talked to, and I reached out to the Bureau of Vital Statistics, we don't have a process to quote issue. You can go to the courts and you can get a certificate, but we don't have a place that you can, after you've gone through the foreign adoption process, that you can then file with the Bureau of Vital Statistics to register that and get a certificate of foreign adoption.
So if they've got a petition that they have to file for the foreign adoption,
Then they have
and
to.
and it's granted by the court, can they just not use the court order to get a new? Can they just bring, you know, I would keep a copy of the court order, go get it at the courthouse and say, here it is, the judge has already issued it, issue me a birth certificate.
So the families are reporting that they are having to go back to court to get these reissued, and they're a tremendous expense. And I've had numerous people reach out on this. So this formalizes the process. This formalizes the process that we put it at the State Department of Health. So we'll have one system and one way to do this. And so it streamlines the system and really puts us in conformity with what other states do as well.
Look, I got no problem. I think I was the one that handled, this may have been my bill that actually passed. And so I'm very familiar with the process because I handled it some 8 years ago. But that's the first I've heard of anybody having a problem with it. And we even set up in the law, we've got the actual petition form that you use to get the foreign adoption certified by the courts. And I'm totally amazed to hear this, they're having a problem. And I would look, I'm not against it. I just want to make sure we're not just creating new laws to create it, or if this is an enforcement issue, we need to let somebody know what's going on.
Well, and this is an issue that was brought to Senator Kaufman, and then I've had a tremendous amount of families reach out that this is a significant issue for them. So that is why the committee looked at it and brought it forth from our subcommittee with the families that were reaching out saying that, and looking at the other states, Senator Robson, I do see that the other states have this process within their Bureau of Vital Statistics where they can get these certificates issued. So this does kind of streamline the process for us and gives them a place that they can go to get those, just like if your child's born here, you can go to them and get a copy of that adoption. So this puts it kind of in the same way to do it.
But they still would have to go through the formalization of the foreign adoption.
Oh, absolutely.
This is just to get the birth certificate.
This is
right?
just the piece of paper with the birth certificate. So.
Right. And look, I'm going to say I'll certainly support this moving forward, but I want to get to the bottom of why they're not getting the birth certificate, because if we've got a petition and a court order that says you issue them a birth certificate, it makes no sense to me why we've got to pass a new law to say you get a birth certificate.
Senator Hobson, that I'm going forth with what these families have reported to me. And so it was a problem and we're bringing it forth.
And I will remind you, it is double referred to public health. So if this passes, it can be looked at. Senator McDaniel.
Question for the author. I've also received concerns from folks across the state. So there is something happening. Not sure what it is exactly, but I'm hearing it as well. You did point out, though, this is in conformity with what other states have done, right? So we're not stepping out into the dark here. We do have some.
Oh, absolutely not. I've looked at what the other states did and do on this issue, and many other states have this exact same process. So this is not revolutionary with what we're doing here. So thank you.
Any other question? Senator Simmons.
Thank you, Mr. Chairman. I don't know if the question is for Senator Boyd or for the drafters, but based upon the exchange between Senator Hobson and Senator Boyd, why would we just amend the existing statute as opposed to creating a new statute?
Council's opinion is it needs to be a new code section.
And why?
Perhaps,
Well, what I was talking with council is this is the code section for the Bureau of Board of Health. And so that allows them to handle it internally instead of somewhere else. So that's why they were putting it in there.
But the language is exactly the same. The language that's in the proposal before us and the language that's in the current law is the same.
This is new language. This would be a new code section.
I understand that, but I'm saying the language that's actually in the bill that will go and be codified as a new code section, is it similar to the language in the statute that Senator Hobson was talking about?
It is.
It is?
yes.
Okay, thank you.
Have a motion?
Title sufficient, do pass.
Motion is title sufficient, do pass. All in favor, say aye. Aye. Opposed? Okay, that carries, and we'll go to public health. I'd like to skip down to Senate Bill 2623, involuntary civil commitments, and that's double referred to county affairs as well. Senator Boyd.
This is Senator Thompson's bill, who is not here to present, so I will go forth and explain it to you. If you will look particularly at lines 106 through 117, the indigent patients that appear before the chancellors, they are asking the treatment for those individuals that need mental health care is quite substantial. They have asked for us to consider this language right here. And it's where that the county residents will bear the cost of treatment by paying a negotiated fee as agreed to by the medical care service providers. They are wanting the authority here to be able to negotiate with those medical providers in the area instead of just paying what the standard rates are. They want the authority to negotiate there. They also have asked, in the absence of negotiated fee schedule, that the medical care service providers will be paid at no greater reimbursement rate than what is the rates of Mississippi Medicaid. So they kind of outline that cost through there with that. I'm sorry.
Well, and I'm sorry, and yeah, Senator Thompson's not here. I said I would weigh in as well. So what the issue that it's addressing is that in at least 2 counties, the mental health community mental health centers, for whatever reason, on indigent patients that the county is responsible for, are telling them that they don't have the beds or they can't do it. So what the counties are asking to do is to go out to, in essence, a private place that they can put when the centers say, I don't have a bed for them, the county who's responsible for them can go to a private facility and place them there. And this allows them to negotiate with those private facilities and caps it at the Medicaid rate, which is what is paid on that. Is that a fair statement? And that's what they're trying to do. The counties are trying to take care of the indigent, but for whatever reason, they're being told there's not beds, even though there may be beds, or they're trying to get beds so that they want to be able to pay for it. That's. Any questions? Senator Turner Ford.
Thank you, Mr. Chairman. Does the bill require that those the fees are negotiated prior to service?
Based on talking with Senator Thompson and the sponsors of this, yes, it gives them the authority. So Because right now, if they were to send them there and they're responsible, they would have to pay whatever the amount that the private facility is charging them, you know. But this is giving them an authority to do is to, yes, enter into a negotiated rate prior to that. So they can go negotiate and say, look, we're going to have this amount of patients and we want to send them to you at this rate. Well, that's what they would be negotiating. That what I've been told is that there are facilities who they can send them to, and they want to be able to enter into agreements to be able to send those indigent mental health people to those places, but they want to be able to address, you know, be fiscally responsible. Does that answer your question? Okay.
And this really comes into play is they've asked to do this so that we are not having them sit in the jail.
Right.
That's really what this is giving them the authority to negotiate. So we don't have those that need mental health services that are not basically being housed in our jails.
I'm sorry, I should have said that. That's what's happening is they come in and they're told you have to go do them, and they're sitting in jails rather than being given the mental treatment that they need, because they're being told they don't have the beds, even though, so they want to go out and try to get them to those places. Any other questions? Have a motion?
Title sufficient, do pass.
Okay, motion is title sufficient, do pass. All in favor, say aye.
Aye.
All opposed? Okay, that goes to county affairs. All right, we'll go to Senate Bill 2338. And this too is double referred to AET. It's a simple bill. If you look last year, this committee, and it was signed into law, passed the bill that allowed for DHS fraud investigation unit to clean up what's going on over there. And that's going on in line 65. It simply adds state auditor. And because we're dealing with public integrity, this was coming on the request of the state auditor. And the way the bill came out last year was it's only going to the Attorney General's office. And this would allow these investigations. If you look at line 64 and 65, fraud investigation unit, district or county attorneys, state auditor, the Attorney General. So they can work together to see who gets those. So that's all it's doing is adding those three words. Any questions? Senator Hobson.
Thank you, Mr. Chairman. Who takes the lead on the investigation if it's reported to, did you say that they're reporting it to the state auditor and the Attorney General? And possibly the DA? Who takes the lead on the investigation?
Yeah, so from the bill that, if you recall, bill was requested by Bob Anderson, head of DHS, so that they could create an investigation unit within there to investigate the fraud and get at the root of what was going on. And so then by that language I just read, it was sent to the Attorney General's office. And by adding this, it can go to the state auditor's office. I will tell you, I think that's really up to them as to where it needs to go. Mine, from experience, if it goes to either of those offices, it's going to be prosecuted in the local jurisdiction of where that alleged fraud happened.
Would it make sense for us to specify who takes the lead? I could see a situation where you've reported it and, you know, people are stepping all over each other to get there. They think they got a good case. You're a former prosecutor. This people are stepping all over each other to get to be the lead to get the indictment or get the investigation, get out in front of the investigation. No offense. I don't mean that, but I just can appreciate that everybody wants to be want to be in charge on this. Under the bill from last year, it was the Attorney General. We received a request from the state auditor for this bill. So again, to my question, who takes the lead if it's reported to all entities? Which law enforcement group takes the lead on the investigation? It's not currently written into the bill. And we can specify that, certainly. Senator Simmons.
Thank you, Mr. Chairman. Mr. Chairman, what is the deleted language on line 31 of the bill?
Just and.
Word
It's
and.
just
Just Ann?
removing, putting and at the end of C.
And that does bring up, if you look at lines 32 through 34, it says reporting to the state auditor, fraud, embezzlement, or abuse. And let me say that part of this was because, and this is when the state auditor's office reached out, that's what they specialize in as a agency. And so that language is in there is giving them the lead on program fraud, embezzlement, or abuse. Senator Boyd.
I think from what I understood about this piece of legislation, it was to give them additional authority with this. I don't think we have a problem right now with agencies kind of tripping all over each other. Having a very long number of years ago worked where we had to interact with different agencies investigating. Usually that's something that's well worked out within the investigators is who's taking lead and what those particular issues are. At the end of the day, we have one of these entities that does a lot of investigation, but we have only one of those that actually can prosecute it and refer those out. So I think I understand the question. I don't think it happens. And I would be reluctant that we pursue anything as to who takes the lead on those situations unless there's some particular instances that are brought forth to us.
Senator McCon, do you have a question? Senator Hobson.
All I was gonna say, I'm aware of one, and one's one too many. Not with these people. I'm not suggesting any of the people that, but I feel like, just like if you go to a crime scene, somebody's got to take the lead on it. If you go to a fire investigation, somebody's got to be the lead on it. And I don't mind if they're all reported to these persons, and hopefully they'll collaborate with one or another. But would it be better for us to specify whose bill is this?
It's mine.
Would it be better for us, Mr. Chair, to specify that who takes the lead in an investigation? And by the way, what is fraud, embezzlement, or abuse? What does abuse entail?
Well, remember, you're dealing with just the DHS issues. So you're just, dealing with, when I say DHS, Department of Human Services, TANF funds, all the stuff that we saw in the news and everything like that. Funds, also programs that are going on. I don't know to the extent that they've had over there, but I know that there's investigations going on within DHS, and it's not just, I guess, an alleged how money got done. I think they're trying to clean that up over there.
I just wonder what the definition of abuse includes. Does that mean any kind of, could it mean anything like abuse of employees or abuse of persons under the care of DHS? Probably, I wouldn't imagine that's what's intended, but could that be included?
Well, I see what you're saying. I mean, I certainly think it all has to do with programmatic, not like somebody abusing somebody over the head or something like that. It's dealing with DHS. If there needs to be a explanation of that word, that's certainly understandable.
I would think if it's an abuse situation, I'm not trying to complicate this too much, but I really just want to know, and I want to make sure we can make it the best product. Certainly, if it's like fraud or embezzlement, that's stuff that the auditor's clearly going to be very aware of and should be looking at carefully. Abuse, I don't know. That seems to me more like an AG or a district attorney type issue, but
If you're asking if you
I don't
want
know.
to take that word out, I think that makes sense.
I'll let the other senators have their piece. I may consider a friendly amendment. Thank you.
Senator Boyd.
I think Senator Hobson's actually brought up a really good point here on the word abuse, because we give authority to the Attorney General's office under the Vulnerable Adults Act to look at abuse. So I do think this is a little bit, I would agree with you on that point of the word abuse.
Okay, you have an amendment?
I do have a quick question here. I'm trying to read through this and I was looking for the word Attorney General. And then I realized it's not in there. If you go to B on 28, 29, 30, and 31, it says to report to the appropriate prosecuting authority and assisting in the prosecution. And then we're adding the state auditor. So in theory, could that not end up with multiple agencies prosecuting? The Hines County DA and the Attorney General's office could both be investigating, and DHS's group?
No, but you have to go look down at line 51 where it talks about the fraud investigation unit. And if you remember last year, that was the whole point of the bill, was to create the fraud investigation unit within the Department of Human Services.
But they wouldn't prosecute. So this is to the
Well,
prosecuting
DHS
authorities.
doesn't prosecute.
Right.
So they were referring that investigation unit was referring it to the Attorney General's office for prosecution.
So that bill itself directs it to the Attorney General and
Correct,
does not
under,
allow.
starting at line 51. That's correct.
Okay, thank you.
And to that end, and I think it goes to what Senator Boyd was saying. Let me put it this way, the Attorney General's office has, whatever, a public integrity unit, it has a couple different units. And people can make reports to their DA's office, or they can make it to the Attorney General's office. And it's up to the Attorney General and the DA of who's going to prosecute it. Sometimes it's the Attorney General's lawyers, and many times it's the DA lawyers. So I think to the point about, how that gets sorted out, I think that's handled by those law enforcement agencies. And the same way with the state auditor too. The state auditor has investigation power, and they look at that, but then they come in and do through the local authorities prosecution. Senator Blackman, you have a question?
I do.
Okay.
Thank you, Mr. Chairman. Now, this section 1 is existing law. Am I correct?
Correct.
Okay, and so we had this fraud investigation unit in place when all of that money was.
No.
We didn't.
The language, this bill, the fraud investigation unit came about as a bill that we did last year that was requested by the head of DHS,
Bob.
by Bob Anderson. That's correct.
That's right. Okay.
So this was not in place. And that's the reason why I certainly explained it. We wanted to clamp down on that or figure it out. And that's why we did that.
Okay. Now, well, in the title, it also has embezzlement and abuse. And in the existing language on line 27, it has as a result of fraud or abuse. So therefore, if we're gonna be correcting, we need to correct it all.
Sounds like a conforming amendment. Would that be the right? To conform it with the amendment with an amendment that passed. Well, I don't think we've had, Senator Hobson hadn't made his amendment. Okay.
Okay,
All
thank
right.
you.
Now, Senator Hobson.
Thank you, Mr. Chair. How about if we put, if the committee's in agreement, fraud, embezzlement, or related crimes in place of abuse? And you also include what Senator Blackman says to bring forward the language in the existing statute to reflect that. That'd be my motion.
Okay. Any questions on, that's an amendment. Any questions on the amendment? All in favor, say aye. All opposed? but also the title. Yeah, okay. So we're on the bill as amended committee substitute. Have any questions on that? Have a motion? Motion's title sufficient, do pass, committee substitute. All in favor, say aye. All opposed? All right, that will go to AET. All right, I'm going to skip down to Senate Bill 2643. Call that up. And that bill's coming out of the task force, the domestic law task force. And I want to, and I know the bottom line is what the bill is doing is adding a 13th ground for what has been called no fault divorce. But as we, I think, heard from the task force chair, that really there's, in other states, there's no fault divorce. It's a version of a ground. And what this bill is doing is making this, making it either party can file a ground for alleging that the marriage is broken. And the standard will then be adjudicated by the chancellor. And in the task force, I thought it was important in the report that they came forward to state what they said. Because, I'm going on record and I've said it is, I personally understand, and the chancellors understand of the laws that we have, which was to promote marriage and family values, and the state promoting marriage and the loving relationship. But as so many times, it certainly over time, it tends to work the opposite way. And I'm just going to read from their task force report so people see that. It is the overwhelming consensus of the task force that legislative action must be taken to amend the code to provide an additional fault grounds for divorce. And they mention about irretrievably broken. The task force further finds that the language of the existing fault ground of desertion is too restrictive and should be amended to remove willful and obstinate. This will allow for the non-deserting party to obtain a divorce from a clearly broken marriage after the continued desertion for the space of 1 year. And they say in here, this recommendation is made first since it is so strongly and consensually held among the task force members, and they give their reasoning. These recommendations would bring Mississippi in line with the vast majority of the country. The reasons for these recommendations are compelling, particularly those who see firsthand the destruction caused to family units by Mississippi's restricted divorce laws. The current system, perhaps originally designed to preserve marriage, does not accomplish that today. Instead, it damages individuals and families, eats up scarce resources, and prevents parties from establishing personally and financially secure households. To be more specific, the current system does not preserve intact marriages. It merely preserves the formal designation of marriage, forcing couples into lengthy separation. Allows a spouse to blackmail the other by insisting on custody or unfairly lopsided property divisions in exchange for ID divorces. Increases the cost of divorce, creates financial problems, embitters spouses, making future successful co-parenting unlikely and thereby damaging children, prevents parties from moving forward, reduces both households' standard of living, negatively impacts victims of domestic violence by causing them to prove abuse and confront their abuser. And there's a number of others. And so this task force was made up of chancellors, domestic law folks throughout the state, lawyers, DHS, and for them, in my opinion, for them to come forward with such a strong statement, I think is indicative. So in turning to the bill itself, the bottom line is it simply adds a 13th ground that either party can file based alleging that the marriage is irretrievably broken. Now, I did have some questions before, which was, does that mean that they can just, you know, oh, I got married and come tomorrow and say, I don't want to be married anymore? No, you have to allege that it's irretrievably broken. Now, there is no time limit. There is the ground of desertion, which requires a year. But if you're married for 30 days and you swear to the court that your marriage is irretrievably broken and the judge makes that finding, then you can be granted a ground of, divorce on that ground. I will also note that in the reasoning, they talked about domestic violence. This legislature passed the spousal abuse as a condition of, I guess, cruel and inhuman treatment. And part of what we heard in the task force, and Chairwoman Cockerham was on it, was how these laws have kept Mississippians the word was used as weaponized. So that's where that's coming from. And so I will open up to any questions. Senator Turner Ford.
Thank you, Mr. Chairman. I just don't know where the language is. Is it still the law that in order to prove the ground of adultery, it requires clear and convincing evidence?
Yes, none of that's being changed.
Where is that language?
Should be.
It may not be. Is it in this section of the code?
It's in the list of, Senator Brang says line 15.
Just don't see that standard. And I didn't know if somewhere over the of the years it has been dropped or if it's located somewhere else. I just didn't see it here.
I don't know, but if you look in line 13, that's where we're adding it. So it's a 13th ground. And then if you look over at line 108, that's the language that's adding the new ground. Upon application of either party may grant a divorce when the court finds there's been an irretrievably broken of the marriage and that further attempts at reconciliation are no longer possible. And I would state that I think that we are trying to promote marriage, but also make not have situations that are detrimental to the family unit. Senator Blackman.
Thank you, Mr. Chairman. So we've eliminated the irreconcilable.
No, ma'am.
Where is that at?
Next section, 352.
So, correct. We are not deleting the irreconcilable differences provisions.
No, but it's not in here as a ground. Okay, so we're adding a 13th ground, but we still have the irreconcilable that will make it 14.
Well,
I think historically it's been considered two different processes.
right.
So yeah, it would be.
ID divorce is not officially a ground of divorce. It's a secondary process. In this 13th ground, why it's done this way is when the task force looked at it, like I said, there were grounds in other states and they were added as a ground rather than what is normally considered a no-fault divorce. And this language is modeled after what goes on in Alabama.
Okay, and one more question. Back to what Senator Turner Ford was saying about the adultery and the clear and convincing evidence standard. Is that a standard that's set by the chancellor since it's not in this statute?
I think that's in the case law. Yes, I don't see, it's not in the statute.
Okay, thank you, Mr. Chair.
Any other questions? Senator Simmons?
Thank you, Mr. Chairman. So the next code section is the section for irreconcilable difference. 9353, if I'm not mistaken. I mean, 2. So that's still, we would do that the exact same way by filing a joint petition by both parties, waiting the 60 days, and then presenting an order to the chancellor.
This bill is not changing that.
Okay. And so with the 13th ground, it would be just like the other 12 grounds where it's a complaint for divorce that's filed.
Yes, but if you look at the language, upon application of either party may grant a divorce when there's been an irretrievable breakdown of the marriage. So yes, it would be the same.
As the other 12 grounds where a complaint is filed and then an answer is filed and there's litigation like all the other 12 grounds.
Right.
Okay,
And
thank you.
if that's correct.
Thank you, Mr. Chairman.
Oh, thank you. Thank you for that. In line. Oh, thank you for pointing that out. So line 21, under the desertion. So if you remember, the 4th ground that's already in law is desertion. Those asterisks are taking out the willful and obstinate portions of the desertion ground. So if you read, it's continued desertion for the space of 1 year. So I guess if we're going to get into that if you, under that 4th ground, not only could you be gone for 1 year, if you're gone for 1 year, you also had to prove willful and obstinate. And what practically speaking has happened in courts is the willful and obstinate. If a person comes back with after 11 months, then the courts have ruled essentially that they came back and that's not willful and obstinate, and the divorce doesn't go through. So by the willful, so on that, if you're gone for 1 year, that classifies as desertion. Does that? And that was a recommendation by the task force. Yes, question.
Thank you, Mr. Chairman. What effect is this change in the code referenced in regards to desertion going to have on a complaint or petition for separate maintenance?
Don't know. I mean, the task force didn't get into that. They weren't charged with looking at separate maintenance. And it's not changing anything on separate maintenance.
Thank you.
Okay. Any other questions? All right. Do we have a motion on the bill? The motion is title sufficient, do pass. All in favor, say aye. All opposed? Okay, that carries. We will, the remaining items will remain on the agenda subject to call. And so that concludes today. Do I have a motion? Motion, rise and report. Thank y'all very much.
But, hey, look, but he did take a picture of it. Okay, okay, okay. I got a copy. And Chris told me that.